to begin with in terms of what we are talking about when we are looking at an inter-country adoption. So that is the adoption of a child who is habitually resident in one country by an individual or individuals who are habitually resident in another country. Okay, so an individual, so it might be a couple, might be an individual, that doesn't make a difference in terms of the concept of an inter-country adoption. And it's really what we're looking at, the focus is the habitual residence of those involved. And the contrast, what makes it an inter-country is the habitual residence of the child is different to that of the prospective adopters. Habitual residence, I haven't gone into defining that. There's been much case law on a concept of habitual resident, but that hasn't really shifted very much. So again, if you want to consult the internet or your favourite legal guide, that is effectively well settled there. As a starting point, again, with the focus being on England and Wales, there are two types of inter-country adoptions. One is very much defined, the other can then be defined further. But the first one is under the terms of the Hague Convention, and in a short moment we'll look at that in more detail and exactly what that Hague Convention entails. And effectively the second group that I'm grouping together are those that are not Hague Convention adoptions. So I start back with Hague Convention. You may have guessed from the start of the talk, you may be familiar with this already, that effectively if your adoption is effected under the Hague Convention, really it's not a walk in the park, but it's supposed to be very smooth from there. Okay, so the Hague Convention adoptions are separated in two parts for the purposes of nationality and immigration, and that is dependent on whether it's finalised in the child's country or finalised in the UK. So here first you have finalised in the child's country. Child adoption under the Hague Convention, as you'll know, automatically recognised, and basically they will be automatically British, the child, even if obviously they hold another nationality, even if they've never set foot in the UK, if at least one parent is British and the parent or parents are habitually resident in the UK. So that's section 1.5 of the British Nationality Act of 1981.